Good morning, everybody, and thank you for joining us for today's CLPD accredited webinar on UAE labor law. So we've decided to host a webinar on this topic because we've received an increased number of inquiries related to employment law and in particular termination of employment contracts in the recent months. And so really what this webinar will be covering is the different types of employment contracts in the UAE, and in particular how they can be terminated, end of service, gratuity, etc. So just as a short introduction, my name is Jean Visser. I am a paralegal here at Fichte & Co. And I will be hosting today's session. As for the structure, we will try to keep it to 1 hour. That is the time we've allocated. So 30 minutes will be spent presenting, and then at the end we will have a 30-minute Q&A session. For that, the first segment, which will be 15 minutes, this will be conducted in English by Anna Mikrichin. She's a paralegal in the shipping department. And then the second 15 minutes will be conducted by Hassan Rabia. He's an associate in our litigation department. Hassan will be speaking for 15 minutes, and then after this, after he's done, we will hold the Q&A session, which will be in English. And I can see that a lot of you have sent in inquiries, and we will do our best to answer all of these. So if you want your questions answered, please hang on until the very end. Yes, so without further delay, I would now like to pass the mic on to my colleague, Anna.
Thank you, John, so much for your introduction, and greetings to all the attendants. Thank you for your time and thank you for being with us today. As my colleague has literally mentioned, today we are going to talk about the different types of contracts, such as limited and unlimited contracts. We are going to cover the topic about end of service gratuity and about the arbitrary dismissal. So to start with, I would like to give you a general background about the employment relationships and how they are governed in United Arab Emirates. So the relationship between an employer and employee in UAE is governed by the Federal Law number 8 of 1980, which we will further call as a labor law. The labor law is structured to be more both employer and employee oriented, and it governs the relationship in UAE. However, if you are a company operating in the free zones, you need to know whether the employment relationship in that particular free zone is governed by that law or by the law related to that free zone. For example, let's bring the example of DIFC, where the relationship is governed by DIFC labor law. Apart from the main labor law, worth mentioning that there are a lot of ministerial decisions which tend to clarify the employment relationship and the clauses mentioned in the labor law. So today, for example, we are going to refer to the two ministerial decisions, so first of which is ministerial decision number 764 with regards to the sample employment contract, and 765 with regards to the termination of employment contracts. So moving forward, let's talk about in general about employment contract and then their types. So what is employment contract? As per the law, employment contract is considered to be every agreement with determined or undetermined term agreed between employer and employee, whereby the employer commits to work for the employer against the remuneration. So as we can literally see from the definition, labor law gives two possibilities of contracts, either with determined or undetermined terms. So we can see in our next slide the difference between these two types of contracts. So let's discuss what's the difference between them. With regards to limited contracts or fixed term contracts, this kind of employment contracts have specified ending and start and end dates. So the contract deemed to be terminated automatically after the end of the date. However, the parties can agree to renew the contract. What about unlimited term contracts? These types of contracts have fixed start date, however, they don't have ending date. So the parties can terminate the contract by mutual agreement or by giving the notice of termination. And that notice of termination must be in conformity with the law, because the notification period can't be less than 30 days and can be more than 3 months. Talking also about the limited contract and their termination, as already mentioned, it can be either terminated or renewed. And what we usually advise client employers, we advise them to inform their employees about their intention either to terminate or renew the contract, because as per the law, where the parties perform their contract without explicit agreement, the contract is deemed to be continued with the same conditions, safe to the terms. So as we talked about the termination of these contracts, then let's move on and see how we can terminate limited and unlimited contracts. In this slide, we can see that we have 6 options to terminate limited contracts. First option, as discussed, is termination by mutual agreement of the parties. Second option is when the fixed term contract is terminated at the end of the term as stipulated in the contract. Third option is whereby the contract is terminated with all the procedures as stated in our next clause, which I will talk about, complying with all the requirements stipulated by law. So what are that requirements? If either employee or employer wants to terminate the contract, they need to give a proper notification, which needs to be due to the notice period agreed between the parties. This notice period must be written in their employment contract. However, as per the law, it can be less than 30 days and it can be more than 3 months. Second requirement as per the law is that the party who decides to terminate the contract shall maintain maintain all the rights and obligations as per the contract until the end of the employment relationship. And third is the payment responsibility of the parties after the termination of the contract. We have 2 more options. So fifth option as per the law is when parties terminate the contract without giving the notification and without keeping the requirements of the law. In this case, the party who terminates the contract shall bear all the causes and consequences of such termination. And the last option, or the last case when the contract can be terminated, is when it's terminated by the gross misconduct of the employer or employee. So if we move forward and see the termination of unlimited contract in our next slide, you can see that for unlimited contracts we have kind of limited options, but there's 4 options. Again, first is the same when you can terminate by mutual agreement. Second option is when either party terminates the contract with giving the proper notification as per the law and as per the contract. Third option is termination by one of the parties without giving notification. However, again, it must be repeated that the party must bear all the consequences of such termination. And the last option, again, for unlimited contract is the gross misconduct of either employer or employee. Such kind of gross misconducts are stipulated also strictly by law, by the articles 120 and 120 of labor code. So after termination, now let's talk about the end of service gratuity. We can see in our next slide that there is a proper a proper article which defines about how it shall be calculated, the end of service gratuity, and we can see that the employer having spent 1 year or more in continuous service shall be entitled to end of service gratuity, and it is calculated in the following manner. If the employer works more for the first 5 years, from 1st to 5 years, it's the employer entitled of the wage of 21 days, and after the 5 year, every additional year, the employer is entitled to the wage of 30 days. However, the case is different for limited and unlimited contracts when employer terminates it. So if we can go to our next slide and see that if based on unlimited contracts, in case of limited contract, the employer is entitled to end of service gratuity when the employment period was more than 5 years, and after continuous 5 years, and when the employment term exceeds that 5 years, it can be end of service gratuity calculated as mentioned in previous slide. And for unlimited contracts, when a worker terminates the contract by his choice, the end of service gratuity is calculated again if the employer has 1 year experience in that company. So if this is unlimited contract, it's calculated in the following manner. If the employer worked in that particular company from 1 to 3 years, the 1/3 of the end of service gratuity can be calculated for the employer, and should the employer has continuous work of 2 from 5 years, 2/3 is entitled, and after 5 years the full service gratuity can be given to the employee. So now let's move forward and also cover the topic with regards to the arbitrary dismissal. Let's see what is in general arbitrary dismissal, because we have talked about already termination of the contracts and how parties can terminate the contract. Arbitrary dismissal is a termination of the contract with the basis not related to the work. This is the case when employer terminates the contract of employee, and employee must prove that such case or such basis to terminate the contract was arbitrary. In order to prove that, the employee must file complaint to the relevant authorities or to the court, and at the end only court or such relevant authority can define whether the cause was arbitrary or whether it court can assess the value of compensation for the arbitrary dismissal. One advice to our client employers, because we have a court decision and court proceedings which states that when the employer don't fulfills its contractual obligation towards the employee, this can be considered as a basis for arbitrary dismissal. For example, was given the payment of the salaries on time. However, let me repeat once again that this only relevant authorities or court's decision to define whether the dismissal was or termination was arbitrary or not. As my time is unfortunately limited, I will give speech to my colleagues, but we will be more than happy to answer to all your questions that you have after my presentation. Jean?
Anna, thank you very much for your useful insights into that topic. And I would now like to pass the microphone on to Hassan Rabia, who will be hosting the Arabic segment of the presentation. Hassan, welcome.
Thank you for the introduction, Jane. And now we will move forward to the Arabic part of today's session. مرحبا بكم، أهلا وسهلا ضيوفنا الكرام. مرحبا بكم في حلقة جديدة من سلسلة الحلقات النقاشية المقامة برعاية مكتب فيشته & كو. وفي حلقة اليوم إن شاء الله حنتكلم عن عقود العمل بصورة عامة، وتفصيلا حنتكلم عن 4 محاور متعلقة بعقود العمل. في المحور الأول إن شاء الله حنتكلم عن أنواع عقود العمل. المحور الثاني حنتكلم فيه عن حالات انتهاء عقد العمل حسب قانون العمل لدولة الإمارات العربية المتحدة. في المحور الثالث حنتكلم عن مكافأة نهاية الخدمة المقررة للعامل، وآخر محور الرابع حنتكلم عن الفصل التعسفي والتعويض المفروض في حالة الفصل التعسفي. ففي البدء نبذة بسيطة عن قانون العمل. مفروض نوضح للسادة المتابعين الكرام إنه القانون العمل حاليا المطبق في دولة الإمارات هو القانون رقم 8 للعام 1980 وتعديلاته. قانون العمل عرف عقود العمل في المادة الأولى من القانون بأنه كل اتفاق محدد أو غير محدد المدة يتم إبرامه بين صاحب العمل والعامل. بموجب هذا العقد يلتزم العامل بأداء عمل معين لخدمة أو في مصلحة صاحب العمل، ويتم الاتفاق فيه على مقابل أجر معين يتعهد بسداده صاحب العمل. دي نبذة بسيطة عن تعريف عقد العمل. حنتكلم عن أنواع عقود العمل في القانون الإماراتي. حسب القانون في نوعين من أنواع عقود العمل: عقود العمل محددة المدة وعقد العمل غير محدد المدة. العقود في نوع ثالث كمان نص عليه مؤخرا في القرار الوزاري رقم 31 للعام 2018، وأوجد نوع جديد من أنواع عقود العمل وهو عقد العمل الجزئي، وده حنتكلم عنه تفصيلا في حلقة منفصلة. اليوم حنركز عن النوعين الأساسيين من أنواع عقود العمل، وهما عقد العمل المحدد وعقد العمل غير محدد المدة. القانون ما عرف عقد العمل المحدد المدة، لكن من اسمه بنقدر نلتمس التعريف الواضح له بأنه عقود العمل اللي تحتوي على تاريخ ابتداء وتاريخ انتهاء. القرار الوزاري رقم 765 الصادر في العام 2015 عرف عقود العمل المحددة المدة بأنها العقود التي تعتمدها الوزارة بما لا تتجاوز مدة عامين. طبعا التحديث ده صدر في العام 2015. قبل العام 2015 كانت عقود العمل المحددة المدة تستمر لمدة 4 سنوات. أما عقود العمل غير محددة المدة بإمكاننا التعرف عليها في 3 حالات. كيف نميز أو نحدد إنه العقد من أنواع العقود غير محددة المدة؟ الحالة الأولى إذا تم النص صراحة في العقد على إنه مبرم لمدة غير محددة. الحالة الثانية إذا كان العقد محدد المدة لكن انتهت مدة العقد واستمر الطرفين في العلاقة التعاقدية بعد انتهاء المدة، ففي الحالة دي يعتبر ده اتفاق ضمني بين الطرفين على استمرار العلاقة العمل، وبالتالي تتحول علاقة العمل من نوع عقد العمل محدد المدة إلى عقد العمل غير محدد المدة. طبعا الفرق بين الاثنين بيتضح لنا في استحقاقات مكافأة نهاية الخدمة وغيرها من الاستحقاقات المالية المترتبة على العقد. ففي فرق كبير بين عقود العمل محدد المدة وغير المحدد المدة من حيث مكافأة نهاية الخدمة المستحقة للعامل. النوع الثالث من أنواع عقود العمل غير محددة المدة هي العقود المبرمة لتنفيذ عمل معين، لكن نوع أو طبيعة العمل المحدد ده غير محدد المدة، زي ما بنشوف كثير جدا في العقود بتاعة الإنشاءات. في هذه الحالة إذا كان تم الاتفاق بين العامل وصاحب العمل على العمل في مشروع معين لحين انتهاء هذا المشروع، فالحالة دي بتعتبر العقد من العقود غير محددة المدة، وبالتالي الالتزامات المالية المترتبة على العقد بيتم احتسابها على حسب العقد غير محدد المدة. في المبحث الثاني حنتكلم عن حالات انتهاء عقد العمل. وحالات انتهاء عقد العمل موجودة في القرار الوزاري اللي تكلمنا عنه بالرقم 765 للعام 2015. القرار الوزاري حدد 6 حالات لانتهاء علاقة العمل في العقود محددة المدة. في حالة حدوث أي من هذه الحالات ال6 تعتبر حالة من حالات انتهاء علاقة العمل، وبالتالي يبدأ احتساب المستحقات المالية لكل طرف من أطراف علاقة العمل سواء كان العامل أو صاحب العمل. الحالة الأولى اللي نص عليها القرار الوزاري بالنسبة للعقود محددة المدة إنه العقد محدد المدة ينتهي بانتهاء المدة المتفق عليها في حالة عدم التجديد. عند انتهاء المدة المحددة في العقد ينتهي العقد تلقائيا، وبالتالي أي التزامات مالية تصبح حالة ومستحقة بموجب علاقة العمل. الحالة الثانية من حالات انتهاء عقد العمل في العقود المحددة المدة إذا اتفق الطرفين العامل وصاحب العمل على إنهاء العقد بالتراضي أثناء مدة سريانه، فأيضا في الحالة دي بيعتبر العقد في حالة انتهاء ويبدأ احتساب المستحقات المالية المستحقة لكل طرف. الحالة الثالثة من حالات انتهاء علاقة العمل في العقود المحددة المدة في حالة واحد من الطرفين منفردا من غير موافقة الطرف الآخر قام بإنهاء العقد، لكن اتبع الإجراءات القانونية المنصوص عليها لإنهاء العقود. طبعا القانون حدد إجراءات أو اشتراطات معينة لازم القيام بها عند إنهاء العقد، وإلا أصبح الطرف الذي يفشل في الالتزام بها ملتزم أو ملزم بسداد مقابل مالي للطرف الآخر سواء كان صاحب العمل أو العامل. الاشتراطات القانونية اللي نص عليها القانون إنه كل طرف لازم ينذر الطرف الآخر برغبته في إنهاء العقد. الشرط الثاني لازم تستمر العلاقة التعاقدية أثناء مدة الإنذار سواء كان الإنذار من العامل أو من صاحب العمل. يجب على عامل الاستمرار في علاقة عمل خلال مدة الإنذار، وإلا أصبح ملزما بسداد مقابل لصاحب العمل في حالة غيابه عن العمل خلال مدة الإنذار. وبنفس الطريقة سواء إذا كان إنهاء علاقة العمل من جانب صاحب العمل يجب على صاحب العمل السماح للعامل بالعمل خلال مدة الإنذار، وإلا أصبح ملزم بسداد مقابل للإنذار للعامل عفوا. الشرط الثالث استمرار علاقة العمل في حالة الإنذار. ففي كل الأحوال دي القيام بواحد من الاشتراطات القانونية المذكورة لازم كل طرف يلتزم بالإجراء القانوني المتبع في حالة إنهاء العقد. الحالة الرابعة من حالات انتهاء العقود محددة المدة اللي هي إذا قام واحد من الطرفين بإنهاء العقد أثناء مدة تجديده. طبعا زي ما معروف أن العقود محددة المدة دائما بيكون فيها شرط خلال مدة معينة، فالتحديد أو كمثال ممكن نأخذ يستلزم الطرفين أنه يقوموا بتجديد العقد خلال مدة 3 شهور قبل انتهائه. فال3 شهور قبل انتهاء العقد دي بنسميها فترة تجديد. وفي الحالة دي إذا قام واحد من الطرفين خلال فترة التجديد وأنهى علاقة العمل مع الالتزام بالاشتراطات القانونية اللي ذكرناها من الإنذار والاستمرار في العلاقة أثناء مدة الإنذار وسداد مقابل للعمل خلال مدة الإنذار، في الحالة دي يعتبر العقد في حالة انتهاء، وبالتالي يبدأ احتساب الفوائد المالية المستحقة للعامل عند انتهاء العقد. الحالة الخامسة من حالات انتهاء علاقة العمل في العقود محددة المدة في حالة قيام واحد من الطرفين بإنهاء العقد بدون الالتزام بالإجراءات القانونية اللي ذكرناها. في الحالة دي سواء كان العامل أو صاحب العمل قام بإنهاء العقد خلال مدة سريانه بدون الالتزام بالإنذار، ففي الحالة دي الطرف اللي قام بإنهاء العقد يكون في حالة اختراق أو في حالة فشل في الالتزام بالإجراءات القانونية المطلوبة، وبالتالي بدل الإنذار يصبح حال ومستحق للطرف الآخر. الحالة الخامسة من حالات إنهاء العقود العمل محددة المدة في حالة قيام صاحب العمل بإنهاء العقد وفقا لأي من الحالات المذكورة في المادة 120. المادة 120 تكلمت عن عدة حالات، في حالة تحقق أي منها يحق لصاحب العمل إنهاء علاقة العمل من غير إنذار العامل ومن غير سداد أي التزامات مالية مستحقة للعامل سواء كان مكافأة نهاية خدمة أو بدل فصل تعسفي أو غيره. الحالات اللي ذكرها القانون في المادة 120 نمر عليها بصورة سريعة، اللي هي في حالة الحالة الأولى إذا انتحل العامل شخصية غيره أو فشل في تقديم أو قام بتزوير أي مستند متعلق بالعمل. الحالة الثانية إذا كان إنهاء علاقة العمل خلال مدة التجربة، ففي الحالة دي يحق لصاحب العمل إنهاء العلاقة من غير سداد إنذار ومن غير سداد أي مقابل مالي للعامل. الحالة الثالثة إذا سبب صاحب العامل خسارة جسيمة لصاحب العمل، أو إذا فشل في الالتزام بالاشتراطات السلامة المحددة، أو إذا فشل العامل في القيام بالواجبات المطلوبة في عقد العمل. أيضا من الحالات المذكورة في المادة 120 في حالة إدانة العامل بأي جريمة متعلقة بالشرف أو الأمانة أو بالآداب العامة، أو في حالة حصل أي اعتداء من العامل على أي من زملائه أو مديريه أو على أي شخص معه في محيط العمل. الحالة الأخيرة من حالات المادة 120 في حالة تغيب العامل عن العمل لمدة 20 يوم خلال سنة واحدة، أو إذا تغيب عن العمل لمدة 7 أيام متتالية بدون عذر شرعي، ففي الحالة دي أيضا يحق لصاحب العمل إنهاء علاقة العمل بدون إنذار وبدون سداد أي مقابل مالي. كده نكون تكلمنا عن حالات انتهاء علاقة العمل في العقود محددة المدة. أيضا حددت في الفقرة القادمة هنتكلم عن حالات انتهاء عقود العمل غير محددة المدة، واللي حددتها أيضا المادة القرار الوزاري 765 للعام 2015، ونص على إنه الحالات اللي تعتبر حالات انتهاء لعلاقة العمل في العقود غير محددة المدة في 4 حالات. نمرة 1 باتفاق الطرفين إذا اتفق العامل وصاحب العمل على إنهاء العقد. الحالة الثانية في أي وقت يقوم فيه واحد من الطرفين بإنهاء العقد بعد إنذار الطرف الآخر واستمراره في تنفيذ العقد. الحالة الثالثة من حالات انتهاء علاقة العمل في العقود غير المحددة في حالة قيام واحد من الطرفين بإنهاء العقد بدون الالتزام بالإجراءات القانونية اللي تكلمنا عنها من الإنذار والاستمرار أثناء مدة الإنذار. وفي الحالة دي الطرف اللي قام بإنهاء العقد يقع عليه عبء تعويض الطرف الآخر عن بدل الإنذار المنصوص عليه في القانون. الحالة الرابعة والأخيرة هي نفس الحالة المذكورة في العقود محددة المدة في حالة قيام صاحب العمل بإنهاء العقد لارتكاب العامل إحدى المخالفات المنصوص عليها في المادة 120 واللي ذكرناها سابقا. كده نكون تكلمنا عن أنواع عقود العمل وحالات انتهاء عقد العمل. في الفقرة القادمة هنتكلم عن المكافأة المستحقة عن نهاية الخدمة. قانون دولة الإمارات قانون تنظيم علاقات العمل قانون رقم 8 لعام 1980 وتعديلاته، ونص على أنه يستحق العامل الذي أكمل سنة أو أكثر في الخدمة المستمرة مكافأة نهاية الخدمة. إذن الشرط الأول لاستحقاق العامل لمكافأة نهاية الخدمة يجب أنه يكون العامل استمر في خدمة صاحب العمل لمدة سنة أو أكثر، ويتم احتساب مكافأة نهاية الخدمة على النحو التالي. في الحالة الأولى إذا خدم العامل في خدمة صاحب العمل مدة أقل من 5 سنوات وأكثر من سنة يستحق العامل أجر 21 يوما عن كل سنة من السنوات ال5 الأولى. إذا استمر العامل في خدمة صاحب العمل أكثر من 5 سنوات في الحالة دي يستحق أجر 30 يوم عن كل سنة من السنوات اللي بتزيد عن ال5 سنوات الأولى. فمثال بسيط عشان نوضح المسألة، إذا اشتغل العامل في خدمة صاحب العمل مدة 6 سنوات، ففي الحالة دي بنشوف الأجر اليومي للعامل بنضربه في 21 يوم عن كل سنة. إذا اشتغل العامل مدة 4 سنوات كمثال بيستحق أجر 21 يوم بنضربه في 4، دي بتكون استحقاقات العامل عن ال5 سنوات الأولى. إذا استمر لأكثر من 6 سنوات زي ما ذكرنا بيستحق العامل أجر 30 يوم عن السنة السادسة وأجر 21 يوم عن كل سنة من السنوات ال5 الأولى. في الفقرة القادمة حنتكلم عن مكافأة نهاية الخدمة على حسب نوع عقد العمل. زي ما ذكرنا إنه استحقاق العامل لمكافأة نهاية الخدمة بيتحدد بيتم احتسابه بواقع 21 يوم عن أي سنة من السنوات الخمسة الأولى، وبواقع 30 يوم أو بواقع أجر 30 يوم فيما زاد عن ال5 سنوات. هذا في حالة إنه نهاية علاقة العمل كانت من جانب صاحب العمل في العقود المحددة المدة تحديدا. أيضا في العقود المحددة المدة إذا ترك العامل العمل بمحض إرادته وقدم استقالته فإنه لا يستحق مكافأة نهاية خدمة إلا إذا كانت مدة خدمته تجاوزت ال5 سنوات. مرة ثانية نفرق بين الاثنين، مكافأة نهاية الخدمة في العقد محدد المدة. إذا كان الإنهاء من جانب صاحب العمل يستحق العامل أجر 21 يوم عن أي سنة من السنوات ال5 الأولى، ويستحق أجر 30 يوم فيما زاد عن ال5 سنوات. إذا كان نهاية علاقة العمل بواسطة استقالة العامل في العقود المحددة المدة قبل تاريخ انتهاء، فإن العامل لا يستحق مكافأة نهاية خدمة إلا إذا تجاوز مدة خدمته 5 سنوات. ده بالنسبة للعقود محددة المدة. مكافأة نهاية الخدمة في العقود غير محددة المدة بنفس الطريقة، إذا كان الإنهاء من جانب صاحب العمل يستحق 21 يوم عن ال5 سنوات الأولى وأجر 30 يوم فيما زاد عن ال5 سنوات. أما إذا كان نهاية علاقة العمل بواسطة استقالة العامل في العقد غير محدد المدة، ففي الحالة الأولى إذا كانت مدة خدمته تتراوح بين سنة إلى 3 سنوات يستحق تلت المكافأة فقط وليس كاملة. إذا في الحالة الثانية إذا كان مدة خدمة العامل استمرت من 3 سنوات إلى 5 سنوات يستحق تلتين المكافأة المنصوص عليها، لأنه استقال بإرادته. والحالة الثالثة والأخيرة إذا زادت مدة خدمة العامل عن 5 سنوات، ففي الحالة دي يستحق العامل مكافأة نهاية الخدمة كاملة حسب ما نص عليها القانون، واللي هي مرة ثانية بنعيدها أجر 21 يوم عن السنوات ال5 الأولى وأجر 30 يوم فيما زاد على ذلك، بشرط إنه إجمالي مكافأة نهاية الخدمة لا تزيد عن أجر العامل لمدة 2 سنين. آخر فقرة إن شاء الله حنتكلم عن الفصل التعسفي. إمتى بنعتبر الفصل فصل تعسفي، والفرق بين الفصل التعسفي والفصل القانوني. الفصل التعسفي جرى تعريفه بصورة واسعة جدا في القانون. القانون ذكر إنه أي فصل لا يمت للعمل بصلة يعتبر فصل تعسفي. الفرق بين الفصل التعسفي والفصل القانوني إنه الفصل القانوني العامل لا يستحق بموجبه أي بدل أو تعويض عن الفصل التعسفي، لكن إذا كان الفصل لسبب لا يمت للعمل بصلة ففي الحالة دي يستحق العامل التعويض عن الفصل التعسفي. القانون نص على إنه التعويض عن الفصل التعسفي يجب أن لا يزيد عن أجر العامل لمدة 3 أشهر، ويتم احتسابه على حسب آخر أجر كان يستحقه العامل. أيضا من الحالات اللي بتعتبر من حالات الفصل التعسفي واللي نص عليها القرار الوزاري 765 للعام 2015 حالة عدم سداد صاحب العمل أجر العامل لمدة 60 يوم أو أكثر. ففي الحالة دي إذا ترك العامل العمل بعد توقف صاحب العمل عن سداد الأجر المتفق عليه لمدة 60 يوم أو أكثر، بالإضافة إلى الأجر المستحق يستحق العامل تعويض عن الفصل التعسفي، ويتم احتساب تعويض الفصل التعسفي بواسطة القاضي في حالة لجوء إلى المحكمة، وهي سلطة تقديرية للقاضي. لكن نص القانون على أنه لا يزيد أجر العامل الأجر عن يزيد التعويض عن أجر العامل لمدة 3 أشهر. في حالة العقود محددة المدة القانون نص على أنه أجر التعويض عن الفصل التعسفي يجب أن يتم احتسابه إذا كان الفصل من جانب صاحب العمل. في حالة العقود محددة المدة العامل يستحق بدل فصل تعسفي مقدار أجر العامل لمدة 3 أشهر أو أجره عن المدة المتبقية من العقد أيهما أقل. يعني في الحالة الفصل التعسفي في العقود المحددة المدة الحد الأدنى للتعويض عن الفصل التعسفي يكون أجر العامل لمدة 3 أشهر. في العقود غير محددة المدة هي سلطة تقديرية للمحكمة، ولكن بشرط أن لا تتجاوز أجر العامل لمدة 3 أشهر. فبكده إن شاء الله نكون تكلمنا عن ال4 محاور المحددة في حلقة اليوم. أتمنى إن شاء الله أنها تكون حلقة مفيدة، وأهلا ومرحبا بكم مرة تانية، ونتمنى نشوفكم إن شاء الله في حلقات قادمة، وشكرا لحضوركم. So now again we have finished the Arabic part. Now you can start the Q&A session.
Thank you, Hassan, for that. I don't speak Arabic, but I'm sure it was very informative. So now we've finished the presentation segment, and we'll be moving on to the Q&A segment. I can see that a lot of you have posted in questions when registering, and thank you for that. We will try to get through as many as possible, but due to time constraints, this might not, we might not be able to do so. In case we haven't answered your question, please feel free to email us and we will get back to you that way. The email address is info@fichtelegal.com. So I think what I'll do is we'll start with Anna's questions first, and then we will move on to Hassan. Okay, Anna, this one is directed at you. If the employer wishes to reduce the salary of his employees, both limited and unlimited, what are the employee's rights and options in this regard? How can the employee protect his rights and collect the gratuity in case they refuse the employer's offer?
Thank you so much for the question, because actually the reduction of the salary is another topic which is very, very common nowadays, and we receive daily a lot of inquiries with regards to the reduction of salaries. However, to give a detailed answer to this question, we need to know what is the reason for such reduction of remuneration, because it differs by law. So the general rule is that the reduction or deduction of the salary must be only based on the mutual agreement between employer and employee, because the change of salary is considered to be change of terms and conditions of the contract, which needs to be duly signed and agreed by both parties. Meanwhile, Article 60 of Employment Labor Law gives the opportunity to the employers reduce the salary solely. However, there are certain cases and requirements which needs to be fulfilled by the employer. Apart from this, we have one recent 2020 ministerial decision in case if such reduction is related to COVID-19 situation, because based on that decision, the companies the decision states that if the employer was affected by COVID-19 situation, they can undertake measures in order to reduce their costs. And one of these reductions can be also deducting from the salary of the employees. However, this is not a golden rule, and you need to be very careful with this. You need to meet all the requirements as stated by laws and by regulations. Generally, again, I will be repeated, but in order to give you a very detailed and precise information with this regard, it's very important to define the cause of the deduction from the salary. So we'll be more than happy to receive your detailed question on our emails, and we'll be happy to give you detailed and precise answer covering all the corners of it.
Thank you very much, Anna. One more question directed at you is, can the employee work for 2 companies at the same time?
Thank you again for the question, very good question. The answer to it is yes, and this is grace to the latest legal reforms that this is possible. Actually, the first time about employment in two places were implemented in labor law in 2010, and after that, on 2018, there was a law with regards to the part-time employment. So what is the rule for that? In UAE, based on the UAE labor law, a person, an employee, can work in two places to get combining full-time and part-time job. So what's the difference between full-time and part-time is that the terms timing of part-time job is less than usual 8 hours. In order to work in two places simultaneously, what employees needs to do is to get the permission from Ministry of Human Resource and Emiratization. Getting the consent from the employer is not required per se. However, in order to get that permission from Ministry of Human Resource and Emiratization, employees need to produce non-objection certificate from the first employer. With regards to the risks of employers in this case, actually they can claim non-competitor clauses and other if they are not agree with the employment of the employees. However, this can be only claimed through authorities and through the court. So just telling that if you are an employer and just telling that you are against for your employee to work in a second place is not an option. That's why what we advise to other clients is to make proper employment contracts defining in advance these clauses, and we are happy to assist in drafting such kind of contracts. Whilst I consider the response was covered your question, if you have any further questions, again, we'll be happy to give you more detailed answer.
Thank you very much, Anna. So now we have a few questions which have been directed at Hassan. The first is, what are the rules and regulations for an employee under unlimited contract who submits a resignation and without waiting for resignation, acceptance, or the period of notice to finish, just leaves the UAE for his home country? He does not even collect any dues like gratuity, etc.
Thank you, Jim, for the question. We have received the same question last month. I guess we have a client. He asked us what the best advice when he terminated his contract. He just sent the resignation to his employer and left the company, left the country. So in this case, we need from our client to have proof that he has officially sent the resignation to the employer. This is the first step. He needs to have proof either in writing from the employer or by email or fax. He sent the resignation to the employer. The acceptance of the resignation is not required as per the UAE laws, just the information, just the employee, he must inform the employer that he is willing to terminate the contract and he is in a process to serve a legal notice. So in this case, the employer, if the employees have left the country without serving the notice period, the employer will have the right to deduct any compensation for the notice period from the employee's end of service gratuity. And then at the end, the employee will be entitled to get his end of service after deduction of the notice period. Because as per the current laws, acceptance is not required. Only the employee should inform the employers that they are in process to terminate the contract and leave the country. However, in end of service gratuity under the unlimited contracts, it's based on the period of working with the same employer. It's either between 1 year to 3 years, then he will be entitled to 1/3 of the end of service. If the employee work between 3 to 5 years, then he will be entitled to 2/3 of the end of service, and then he will be entitled to the full end of service in case of working for the same employer for more than 5 years. So I hope this has answered the questions, Jane.
Thank you very much, Hassan. We have now received a question for Anna, which is that can a limited contract be renewed after 4 years?
Actually, I'm very grateful for this question because it will give me the possibility to point out one very common confusion with regards to the limited contracts. Actually, if we go to the labor law, we can see that the limit imposed for the limited fixed term contract is defined to be 4 years. However, if we go to the ministerial decision number 765, we can see that it's stipulated that limited contracts cannot exceed 2 years. So this confusion between 4 and 2 years is very common, and I would like to inform everybody that the limited contract actually cannot exceed 2 years. So the termination time for the limited fixed time contracts as per the law is defined to be 2 years. Whether it can be renewed, the answer is definitely yes, as per the consent of 2 parties. After the termination of limited contracts, it can not only be renewed, but it has other options as well. It can be, as already discussed, it can be terminated, or parties can agree to make a new contract with unlimited term. So to change the limited contract to unlimited term contract. Those are the options that parties can have. But as already mentioned during my presentation, what we really advise to our clients, employers, or even employees also, this is advisable, that to inform their employers or employees about their intention before the end of the contract, whether they are going to renew it or whether they want to terminate the contract, because as stated, after the termination, if the parties explicitly executing their rights under that contract, it deems to be continued except for the terms. So the answer to the question is the contract can be renewed after 2 years of after limitation of that 2 years for fixed term contracts. I hope I gave the answer to the question.
Thank you very much, Anna. Now moving on to Hassan. A question for you is, can an employer transfer an employee contract to work for another company registered under their name?
Thank you, Jane, for the question. We have a similar case now we are handling. This is happen when an employer wants to send his employee from, let's say, A company in Dubai to B company in Sharjah. In our case, what we have, an employer, he wants to send the employee from A to B company, and he was faced by refraining from the employee to be transferred from one company to another. So in this case, it's clearly, as per the law, it's permitted to the employer to send any employee from A company to B company for some conditions. First one is both companies should be owned by the same owner, and the second condition is he will be the employee should be sent to the other company based on the same salary and same designation. If all of these conditions are met, and then the employee have no option to be transferred to the other company once it's been owned by the same owner. So it's allowed by the law to transfer the employee from A company to B company owned by the same owner for the same salary and same designation. So I hope this has answered the question, Jane.
Thank you very much. Next question, is overtime pay acceptable to managers and supervisors in DMCC? Is an oral employment contract recognized in DMCC?
Thank you for the question, Jane. Before going to the answer, we need to know whether labor law is applicable on DMCC or not. So the answer is yes. Unless any free zone has its own labor law, the public labor law is applicable on all in all the country. So, for example, we have the IFC. This is the only free zone has its own labor law, so it will not be applicable over there. But aside from the IFC, any free zones it's been restricted by the labor law number 8 of the year 1980. So the answer for this question is no. There are four categories are not are excluded from the having the overtime pay. So the overtime pay is not applicable for number one, chairman and board of directors. Then it's not applicable for general managers of the company. They cannot be entitled to get any overtime pay. Third category is the supervisors also. Any supervisor in each company is not entitled to get any overtime pay. Plus the last category which is not entitled to get overtime pay is the head of departments. Every manager in every company is not entitled to get any overtime pay because this is excluded by the law. The normal employees and normal categories, they are entitled to get the overtime pay if they are working for more than 8 hours as per the law, and they are being requested by the employer to work for overtime, then they will be entitled to get the overtime pay. Aside from that, these four categories are not entitled to get the overtime pay. So this is the answer for the question, Jane.
Yes, Hassan, thank you very much. We'll now move on to Anna. I've received a question which is directed at you, and that is that is a labor contract the same as an employment contract?
Very interesting question. Actually, from one point of view, we can consider that they are the same, labor contract and employment contract. And this is the case if we are talking about the same two notions in different legislation. In UAE, there is a slight difference between labor contract and employment contract, and I will tell you what's the difference between these two. As I already mentioned in my presentation, we have decision 764, which talks about the sample employment contracts. And in general, in order to get your employee, you need to sign a sample contract, which is that labor contract, which needs to be both English and Arabic. And this contract needs to be submitted to Ministry of Human Resource and Emiratization. This exact contract, which is submitted to Ministry of Human Resource and Emiratization, is considered to be the contract which governs the relationship between the employer and employee. We have a lot of cases that apart from that employment contract which was submitted to the ministry, employers tend to also conclude one supplementary contract where the basic terms needs to be identical, the same as it was submitted in the contract which was submitted to Ministry of Human Resource and Emiratization. However, it can be more extended. For example, it can explain all the clauses that were agreed between the parties. So this is the slight difference between labor contract and employment contract in UAE. However, worth mentioning that the relationship between both parties is governed only by the contract, which includes all the details about employer-employee wage amount, rights and obligations in the contract, which was submitted to the Ministry of Human Resource and Emiratization in both Arabic and English languages. I hope I gave the answer to your question.
Right. Thank you very much, Anna. We've just received one more question for you. I hope you don't mind, and if time allows. And that is, does a part-time contract have the same rules and penalties as a limited or unlimited contract?
Thank you for the question. Actually, unfortunately, my time is limited because about part-time contracts we can talk unlimited, and there are a lot of things to cover. But to give you a short overview and to give an answer to the point, I will tell that the answer is yes. The part-time contract is subject to the same rules and penalties as to the main employment contract. What's the difference between part-time and full-time contracts? Actually, in 2018, there was issued a ministerial decision number 31, if I'm not mistaken, with regards to all the requirements for the part-time employers and employees, sorry. And this was a very good change because now employers have the opportunity to hire not only full-time employees, but also part-time employees who are specified in some kind of tests and who can do the job less than 8 hours, which is in general prescribed for full-time employees. So the main issue here is that a part-time worker needs to get the approval from Ministry of and Emiratization, and based on this decision, this resolution, we have initial and secondary employer notions, and in this framework, the employee who wants to get the part-time job from another employer needs to get non-objection certificate from the first employer. And the main requirement in general is that the working hour must not exceed 20 hours weekly, and 8 hours must not exceed 8 hours daily. So it needs to be less than general full-time employees' work time. Actually, in that resolution, there are a lot of detailed information with regards to requirements for part-time work, part-time employment. However, unfortunately, my time is limited to give you the complete overview. But if you have any specific question with regards to that, you can write an email and we will be more than happy to give you detailed and more complete answer to any of your questions. Thank you, Jeanne.
I appreciate that we are running out of time, but we have received a very large number of questions, and if you guys would allow, we would just like to ask one more question of Hassan, and that is, if I decide to resign before I complete 2 years, will I face a travel ban under limited or unlimited contracts?
Thank you, Jane. Thank you for the question. And the answer for this is very simple. According to the current applicable laws, there is no travel ban in the labor cases, unless there is a criminal act conducted by the employee. But I guess the question is asking about the prohibition of work, not the travel ban, the ban from working. I guess this is, as per the law, is being applicable based on the type of the contract. So in limited contracts, before the end of the contracts, if the employee resigned before the end of the contract, the employer shall have the right to file a prohibition for 1 year to ban the employee from work in any other company in UAE for the period of 1 year. So this is granted by the law. If in an employee for limited contracts, he wished to resign, he can resign, but again, the employee will have the right to reach out the MUHRI, Minister of Human Resources and Emiratization, and he can prohibit the same employee from working in any other company for a period not exceed 1 year. This is in terms of the limited contracts. In unlimited contracts, it's not applicable. It's only the right for the notice period, unless the employee is being served by the by the notice period, he will not be entitled to claim any compensation from the employee. So again, we will confirm that in case of limited contracts, there is no travel ban, but there is a prohibition. It can be filed by the employer in Muhri to prohibit the employee from working in any other company in UAE for a period not exceed 1 year. This is happen in case the employee resigned before the end of the term of the contract. So in general, no travel ban in labor law unless there is criminal action by the employee, but there is prohibition from work for 1 year in case of limited contracts. So I hope this answers the question. Jane?
Thank you very much. And I am conscious that we've run over time, so I think we will wrap it up there. I just want to take this opportunity to thank Hassan and Anna for taking time out of their busy schedules and for giving us these valuable insights into the topic. And I would also like to thank all our attendees for engaging and asking so many questions. I do appreciate that we haven't been able to get through all of them, but I do encourage you that if we haven't been able to answer your query, do send us an email at info@fichtelegal.com, and one of the lawyers will respond to you that way. And otherwise, I would encourage you all to follow us on our social media accounts such as LinkedIn, Twitter, and YouTube, because we have a series of webinars that we'll be hosting in the coming months, and this might be of interest to you. So yes, thanks again everybody for attending today, and that concludes our session.